Before we proceed, please note that AI is only used to make the video, but all the content is manually researched and it's not AI generated. Hi, I'm Supriya Gill, a lawyer, and in this video we're going to dive into some crucial aspects of the Violence Against Women Act, or VAWA. Specifically, we'll discuss the common reasons why VAWA applications get denied and share some key takeaways to help you avoid these pitfalls and increase your chances of a successful petition. What is VAWA? VAWA is designed to protect victims of abuse who are in an immediate relationship with a United States citizen or green card holder. It provides them with important immigration benefits. However, despite its noble purpose, not all VAWA applications are successful. In fact, statistics show that about 25% of VAWA applications are denied. This can be a huge setback, not only emotionally but also in terms of time and money. But many of these denials happen due to common mistakes that can be avoided. Common reasons for VAWA application denials. Let's go through the most common reasons why VAWA applications get denied and how you can avoid these issues. Mistakes in the application. Mistakes in your VAWA application can lead to denial. This is why it's essential to work with an experienced immigration attorney. If your case has complex facts or a complicated immigration history, trying to handle it alone could result in costly errors. An attorney will ensure that all forms are correctly filled out and that accurate information is provided. Filing location. Inaccuracy. VAWA applications must be submitted to specific locations, depending on factors like the abuser's immigration status and the courier service used. Filing in the wrong place can cause delays or outright denials. Consulting with an attorney can help you determine the correct filing location and avoid this issue. Missed filing deadlines. While you can apply for VAWA at any time after experiencing abuse, there are specific deadlines if you are divorced from your abusive spouse. If your VAWA petition is based on that marriage, you must apply within 2 years after the divorce is finalized. Missing this deadline could result in denial. An attorney can help you keep track of these critical timelines. Insufficient documentation. Your VAWA application needs strong documentation to prove the relationship with the abuser, the occurrence of abuse, and the genuine nature of the marriage. Without enough evidence, your application could be denied. An immigration attorney can guide you in gathering and organizing the necessary documents to build a compelling case. Hiring non-attorneys or unqualified attorneys. Unfortunately, hiring an inexperienced or unqualified representative can jeopardize your VAWA petition. Some attorneys may lack the necessary expertise in immigration law and might miss important details. It's crucial to select a licensed and experienced immigration attorney with a proven track record in handling VAWA cases. Missing appointments and deadlines. The VAWA application process includes various appointments, such as biometrics collection and interviews. Missing any of these appointments or failing to respond to requests for additional evidence can lead to denials. Staying engaged with your legal team can help you stay on top of these important dates. Failed to provide evidence for a bona fide marriage. If your VAWA application is based on an abusive marriage, you need to prove that the marriage was genuine. This means providing evidence like joint finances, shared children, or family statements. A marriage certificate and wedding pictures alone might not be enough. An experienced attorney can help you compile this evidence, even if the abusive situation makes it difficult to gather certain documents. Unable to provide sufficient evidence of abuse or extreme cruelty. A key part of your VAWA petition is proving that you were a victim of abuse. Without solid evidence, your application could be denied. It's important to work closely with your attorney to provide the necessary documentation and testimonials that support your case. Failed to establish cohabitation with the abusive spouse. VAWA requires you to show that you lived with your abuser at some point, even if only for a short time. If you can't provide evidence, such as a joint lease or shared bills, your application might be denied. Statements from friends or family who know about your living situation can also be helpful. Your declaration is not strong. One of the most important pieces of evidence in your VAWA application is your declaration. This is your chance to tell your story, how the relationship started, how the abuse occurred, and how it has affected you. If your declaration isn't strong or credible, it could hurt your case. An attorney can guide you in crafting an effective declaration. Getting married while your VAWA application is pending. If your VAWA application is based on abuse from a former spouse, getting remarried while your application is pending will result in a denial. You must wait until your VAWA application is approved before considering remarriage. Conclusion. Applying for VAWA can be a complex process, but understanding the common pitfalls and working with a qualified attorney can significantly improve your chances of success. I hope this information helps you on your journey to a successful VAWA petition. If you like this information, don't forget to subscribe. It will be a great support.